Good morning, good afternoon, good evening, good whatever time of day it is. Thank you for watching Conversations with Dr. Don. My guest this evening is Dan Meek, who has got so many things going in his life and in his career that it's very exciting to have him on again. I have him on periodically to bring me up to speed with what's going on in Salem, in the legislature, and other stuff to do with laws and the rules that govern our behavior and how our state and our community and our country is run. He blows me away every time. So Dan, thanks again for coming on. How are you feeling?
Pretty good.
Okay.
Or should I say pretty discouraged? I mean, this is a time of year that is not always very optimistic for me. The Oregon legislature is in its last week or two of the session. This is when they eliminate all public notice requirements so they get their real work done. And
eliminate all public notice requirements?
Oh, yeah. During the year, during the legislature's in session, they start in January of odd-numbered years and usually go about 6 months, but they can go longer. For most of the session, their rules require that if they have a hearing on a bill, there has to be public notice like 48 hours in advance. But now they suspend all notice requirements and they just do whatever they want. If you're not there, not there in Salem, in the room, then you don't know what's going on.
And that's democracy.
That's democracy in Oregon, yep. And on the national level, not always, but over the past couple of decades, a discouraging day is always the day before that the United States Supreme Court ends its session. It always ends its session at the end of June, so it can take July, August, and September off, take vacation and whatever. So they issue a whole lot of decisions at the end of June. And for the last 20 years at least, the Supreme Court, the decisions that they issue are alarming to say the least. So they've issued 4 of them, they've issued many in the last 2 days, but 4 of them in particular are I think worthy of discussion.
Very important, yes, yes. Now, I didn't finish my intro. I got interrupted by introducing you earlier than I like to. For your first-time viewers, Conversations with Dr. Don is an ongoing series of 1-hour standalone talk shows where I interview interesting people like most of you out there about who they are as unique, one-of-a-kind individuals. And Dan Meek, of course, is always interesting, and that's why I've got him on again. So let's go to a brief version of the Who Are You segment, which I usually start my shows with, so that people have an idea who you are, where you're coming from, and why it is you think the way that you do when we talk about the issues that you're going to talk about. If I were to ask your best friend, who is Dan Meek, what would your best friend say? Dan Meek is what?
Oh man, I don't know. An attorney obsessed with I don't know, the public interest, who wastes a lot of time on causes that don't succeed. I don't know.
And has a wonderful sense of humor about himself and what he's about.
I guess.
Yeah, it must be pretty fatiguing and tiring to get this time of year and seeing what's going on in Salem particularly, not to mention what's going on in Washington, D.C. with SCOTUS. And when and where
it
were you
sounds
born?
like a part of the body, but I think you mean the Supreme Court of the United States.
It's a family show. I know. I always feel that way when I say SCOTUS.
Just don't say scrotus, I guess.
Shh. Are you a native Oregonian?
No, I was born and grew up in Pocatello, Idaho.
Idaho. Whoa, that's interesting. You're a right winger, a Tea Partier?
No, I'm probably the most liberal person I know. I would think, and back then, Pocatello, Idaho was not a right-wing place at all. It had a lot of railroad workers, unionized railroad workers, and it also is where Idaho State University is. So it was quite a liberal bastion. As I recall, back when I was in high school, Republicans didn't even run for office.
It's come a far piece since then.
It's changed a lot, yes.
Yeah.
I think the legislature is 85% Republican now in Idaho, and even in Pocatello, Democrats aren't at all competitive.
Trick question, you ready? Why were you born?
I don't know, good planning. No, I will tell you why.
He handles, no matter what I throw at him, he handles
why.
that.
Because my mother had her fallopian tubes blown when she was 42. That's why.
Okay.
I was stuck. I was stuck up in the womb. I couldn't get out until the doctor cleared out the tubes.
Is it a fair question? Is it a fair question to ask you about the religious preference, or is it going to cause you any problems in Salem?
It shouldn't. I have no religious preference whatsoever.
Mm-hmm. And you're an attorney by education.
Mm-hmm.
So what do you do now to feed yourself and keep a roof over your head?
Oh, the last 3 or 4 years, nothing. That is, in the past, I have succeeded in some class action litigation, mainly against utilities for cheating ratepayers, and have earned some court-awarded attorney's fees. But most of my practice is just for public interest groups and organizations, and I'm not paid for that. So most years now, I'm not paid by anyone for anything.
Do you have some other secret source of income?
The attorney's fees that I earned in past years.
Oh, I was wondering if you're involved with the cartels in Mexico.
No, I deny that.
Do you have a partner?
Yes, Linda Williams.
Mm-hmm. And she like you?
I don't know. Well, she must.
She puts up with you.
She
Huh?
must.
Yeah, and your political persuasion, need we guess that you're something other than left?
Populist.
Liberal? Populist.
Populist.
Why do you choose that term rather than liberal or leftist?
Well, I think the difference is populism is I suppose, defending the little guy, and
Yes.
that's not always the same as liberalism, but it's frequently the same.
Yeah, yeah. Memberships in political, social, or civic organizations, you belong to anything worth mentioning. I'm an ACLU member for 40 years, I think, for example.
I'm a member of the Progressive Party of Oregon.
Yeah, so am I.
All right. And other organizations here and there, Osberg,
Osberg, say what that
Sierra
means
Club, that sort of thing. Oregon State Public Interest Research Group, an organization that Ralph Nader founded in the 1970s, early 70s, late 60s.
Nader, yeah.
Right.
Yeah. Persons from the past that you liked or admired, any names come to mind right now? Alive today or from the past?
Well, Ralph Nader,
Ralph
obviously,
Nader. Mm-hmm.
is sort of the ultimate sort of model, I guess.
What a human being, huh?
Mm-hmm.
Yeah. What about Nelson Mandela? We're about to lose him.
Him too.
Yeah.
And of course, Vladimir Putin.
Did I start this? Somebody help me over here. What are your views about... never mind, skip that. How do you see the mainstream media? Is it left, right, or centrist, generally speaking, in America?
Right.
Right, yeah. Do you read, view, or listen to any alternative media?
Democracy Now!
Amy Goodman?
Amy Goodman.
Mm-hmm.
I listen to KBOO quite a bit.
Mm-hmm.
When it's not playing classical music or other musical things.
Mm-hmm.
Alternative media, and I get most of the media that I get now is off the internet,
Mm-hmm.
and reading newspapers and common common ground. What is it? Common.
I know.
Yeah.
I know.
Okay.
There's about a half a dozen of those that I do religiously. Yeah.
I even have in the past rather often read Glenn Greenwald, and now he's making big news.
Yeah. Oh, I'm about to jump ahead here on you. Who's the latest fellow who is looking to get to Ecuador?
I mean, Edward Snowden.
Snowden. Yeah. What do you think of him?
Well, I hesitate to say anything because I'm not interested in being prosecuted for my views. So I think I'll leave it at that.
Yes. Okay. What's wrong with America today?
The wealthy and big corporations are 100% in charge.
Yeah, excuse me, yeah. How do we fix what's wrong?
Good question. I don't know. I've been trying to do it for a long time without a great deal of success.
I mean, can we start with a move to amend doing something about that Supreme Court decision that says corporations are persons?
Well, that certainly could be done. That's going to be a very difficult task. It will require the Congress to pass a proposed constitutional amendment by 2/3 of both the House and Senate, and then it goes to the states, where 3/4 of the states have to ratify it. That means 38 states have to ratify it, and that means basically 12 states have a veto. And when you consider that 22 states gave their electoral votes to John McCain, and I think 23 states gave their electoral votes to Mitt Romney, that's really probably not going to happen. Particularly, it would require states in the South and in the Mountain West to vote for it.
Yeah.
So there are other ways that could be that the Citizens United decision that I think you're referring to, could be overcome, but Congress really failed when it was possible to succeed. Citizens United decision came down in January of 2010. At that time, the Democrats had large majorities in both the House and the Senate. They had 59 to 60 members in the Senate during that session. They had a large majority in the House as well. Mm-hmm. They could have done something about it, as we might get into later. Among the things they could have done is remove the jurisdiction of the United States Supreme Court to overturn campaign finance laws. The jurisdiction of the United States Supreme Court is dictated by Congress. It says that in the Constitution. All they would have to do is say, from now on, we pass a law that restricts campaign contributions or expenditures. The court has no jurisdiction to overturn it. They could have done that with their overwhelming Democratic majorities in the House and Senate, but they didn't even try.
Why didn't they do something about it?
Well, I think back in 2010, they were operating on the basis of history of contributions they had been receiving over the past few election cycles. And in the past few election cycles before that, like in 2006 and 2008, the Democrats actually got more money from corporations and persons who, executives of corporations, than the Republicans did. So they thought, Citizens United just, unleashes corporate money. Who cares?
Who cares?
Who cares? That's good for us.
Uh-huh.
But it turns out that it wasn't good for them, because it was that giant tsunami of corporate money in 2010, in October, in late 2010, that elected the Republican majority to the House. And as long as the House has a Republican majority, virtually no reform can be done of campaign finance. Mm-hmm. So they had Democrats had an opportunity in 2010 to do something, and they did nothing.
Yeah.
And it makes a difference, because now they're in a position where they have to take back the House in order to even try to have any prospect for doing anything at all, and that's going to be hard. That's going to be hard to do.
So, kind of digressing for a moment, I was reading on the internet today about a simple statement somewhere in the Constitution that says all citizens have a right to vote. That isn't in the Constitution anywhere.
No, it's not. It's not in the Oregon Constitution either.
How'd that happen?
I said maybe it was just assumed that there is a right to vote, but there isn't. And one thing that I would like to discuss is the two cases that the United States Supreme Court issued, the two decisions they issued just in the last 2 days about voting, mm-hmm. because they're very important. The first one is the Shelby County case. It's called, as the slide indicates, Shelby County, Alabama versus Holder. Uh-huh. Holder is Eric Holder, the Attorney General of the United States. Yeah. And this decision struck down part of the Voting Rights Act of 1964. Now, that act was, I think it's 65 actually, that act was to enable minorities to register and vote where their rights were being denied, which was in the southern United States. Back then, you would have counties all over the South, the historical states of the Confederacy, where you might have, the population might be 50% black, but the registered voters would be 0.0001% black.
Yes.
You'd have 30 or 40,000 African Americans in a county, and literally maybe 3 or 4 would be registered out of 40,000.
Yeah.
The Voting Rights Act required elimination of some of the techniques that were then being used to disqualify blacks from registering to vote, like poll taxes, literacy tests that actually weren't literacy tests; they were just tricks.
Yeah.
Literacy tests with trick questions. And as my slide indicates, other ways to prevent African Americans from registering to vote. Among the other ways was if an African American did try to register to vote and registered to vote, one of the ways that was discouraged was that person would be shot on the way home. So that was the situation. And what the act also did, as the slide indicates, that it required in those states pre-clearance for any changes to voting laws, because they can be very creative in changing the laws in order to disenfranchise people.
The disenfranchising.
That's right. And so Congress came up with this map of where pre-clearance was required, and that's in the red areas, which is essentially the states of the Confederacy, except not all of Florida and not all of North Carolina. Plus, there are individual counties in Florida, North Carolina, South Dakota because of the Native American population, Alaska also because of the Native American population. We're also subject to
and Alaska
barriers
too,
to vote. Yeah.
Uh-huh.
So these were the states that were covered by the pre-clearance requirement. You can't change laws about registering to vote without getting approval from the Department of Justice.
As a result of that bill.
As a result of that bill. And in 2006, Congress reauthorized the act and kept these same areas as being those that required pre-clearance. So what the U.S. Supreme Court did yesterday is it decided that Congress was wrong in 2006 in using the same areas, the same states, because recent data indicates that, my goodness, minorities are registering to vote and are voting. Well, so therefore, since they're voting and etc., they don't need the protections of the Voting Rights Act anymore. It's kind of like saying, a lot of people stop at stop signs, so we should remove all the stop signs because there's not a problem anymore with people having traffic accidents.
Hello.
Yeah, it says that when you have a law against something, and that discourages the something, in this case, deprivation of voting rights that you want to discourage, that the mere success of that law means that the law has no justification. See what I mean?
Yeah. Oh, the way they get around it, and just human nature.
You could use that rationale to invalidate almost any law that's effective. Oh, the law worked, therefore there's no need for it, and there's no justification for it.
And these conservative Supreme Court justices, oh man, I can go off on that.
That was the usual 5-4 that we've come to expect. The 4 conservatives plus Justice Kennedy versus the 4 liberals. Just yesterday, a different case was decided, the Arizona versus Intertribal Council case. And this was sort of hailed as a victory by liberals, but in fact it isn't. And this actually was, as I recall, a 7-2 case. Wasn't the usual 5-4. In this case, it was about Arizona's law that said that you have to provide some proof that you're a citizen in order to register to vote. Mm-hmm. And Arizona can require that proof when it comes to voting in state elections. But there's a federal law that says that the federal government will come up with a uniform voter registration form for federal elections.
Yes.
That every state has to accept that form. And on the form, there's a checkbox that says, "Are you a U.S. citizen?" And you can either check it or not. Mm-hmm. If you don't check it, obviously you're not registered. You don't get registered to vote.
Yes.
If you do check it, then you're considered, whether or not you're a U.S. citizen, you're considered to be a U.S. citizen, and the state is required to accept that form.
And that's enough.
And that's according. Well, not exactly. That's where the decision gets a little bit more complicated. The decision said that you have to accept the form, which means you have to register for federal elections anyone who fills out the form and checks the box. However, the decision also indicated that states set the qualifications for voting in all elections, including federal elections, and that states can deny registration based on information in their possession establishing the applicant's ineligibility. So even if you accept the form, you can then check it against records of Social Security numbers or whatever, and still disqualify that person from voting in state and federal elections. So this decision was hailed as a great victory. It wasn't so much a great victory as just kind of a clerical thing. Yeah, you got to accept the form, but that doesn't prevent you from disqualifying these folks unless they prove their citizenship.
Hey, the devious ways of the law. Right.
Now, a third decision, which came out today, was the decision that struck down the Federal Defense of Marriage Act. DOMA, which was a law that Congress passed that said that the only kind of marriage that the federal government recognizes for all purposes, and taxation and whatever, is a marriage between a man and a woman. And so it was a woman in New York who challenged that because she had to pay an extra $300,000 or so in federal estate tax because her spouse, her female spouse, died, and she was not able to take the exemption, the federal exemption, spousal exemption for estate tax. So the majority decision said that was that recognizing only heterosexual marriage was a denial of equal protection under the Fifth Amendment of the U.S. Constitution, and the majority was the usual majority that you would expect, the four liberal, I put liberal in quotation marks,
yes,
the four liberal judges plus Justice Kennedy, with the four most conservative judges dissenting. An interesting element of it is that the Attorney General of New York, the Attorney General of the United States, Eric Holder, refused to defend the law. Now, when a law is challenged, a federal law is challenged as unconstitutional, the Attorney General of the United States has the I thought, the duty to defend the law. Yes. They said, we're not going to defend it, so there's nobody in court to defend the constitutionality of the law. So the folks who defended the law was an ad hoc advisory group of the U.S. House of Representatives. That is, after the U.S. House of Representatives went Republican, they appointed this little ad hoc advisory group to go defend the law in court. And the court said today, well, that's fine. There was somebody in court defending the law, so that's good enough, and we strike down the law.
Why didn't the Attorney General defend it?
Well, because he didn't like it, I guess.
But he's part of the administration.
Yes.
Oh boy. Okay.
This gets even more interesting with the other case that was decided today, and that was as the slide indicates, Hollingsworth versus Perry. This was the case about California Proposition 8, which was a ballot measure that passed in 2006 or 2008, which prohibited same-sex marriage in California. Now, the California legislature had never authorized same-sex marriage, but the courts in California, including the California Supreme Court, had ruled that under the California Constitution, same-sex marriage had to be allowed. So it was allowed. So then California Proposition 8 came along, amended the California Constitution to ban same-sex marriage. So that ban got challenged as a violation of the U.S. Constitution. You would the same sort of equal protection arguments that were used to invalidate DOMA, the Defense of Marriage Act. The U.S. District Court in Los Angeles, a judge of the U.S. District Court, there are about 400 such judges, ruled that indeed California Proposition 8 violated the United States Constitution on equal protection grounds. So at that point, it had to go to the federal court, Ninth Circuit Court of Appeals. But the state of California said, well, we don't want to defend this anymore. We don't want to defend Proposition 8, even though it was enacted by a majority of the voters of the state. So what happened then is that the essentially the chief petitioners, the people who had put the measure on the ballot in the first place, were allowed to defend the constitutionality of the measure. And the federal courts actually sent back to the California Supreme Court the question, do these, the chief petitioners basically on the measure have the standing and authority under California state law to defend the measure if the state of California refuses to defend the measure? And the California Supreme Court said yes, yes they do. So that case then went to the U.S. Supreme Court, and it was not the usual majority decision that you would expect. It was 5-4, but it wasn't the usual 5-4. It was probably a unique 5-4. The majority of the 5 was Chief Justice Roberts, Justice Scalia, Justice Ginsburg, Breyer, and Kagan.
How can those people vote the same way?
3 of the more liberal members of the court and 2 very conservative members of the court. And the decision doesn't look at Proposition 8 on its merits at all. There's nothing in the decision about the constitutionality of same-sex marriage. Absolutely nothing. The decision, which was written by the Chief Justice, is all about who has authority to defend a ballot measure in court. That's what the decision is about completely. And what they decided is that if the government, in this case the state of California, declines to defend the constitutionality of a ballot measure that's enacted by the voters of California, nobody can defend it. Therefore, and in this case, here's how it works out. Before the federal district court, the challengers were saying that the Proposition 8, violates equal protection, etc. The state was defending it at that time, so there was, a case or controversy. There was, and the district court issued the decision saying that it, violates equal protection, etc. Then the state of California says, well, we're not going to defend it anymore. So the result of that is that it makes the U.S. District Court decision, which is just the decision of a judge, one of 400 judges, unappealable. Now, you might like the outcome in this particular case, and I love the outcome. I think same-sex marriage should be available to everyone. But it's very dangerous for the initiative process because it means that if the state refuses to defend the constitutionality of a ballot measure that's enacted by the voters, that's it.
Just throw it away.
Nobody else can be there to defend the measure. And the interesting dissent, if you look at the next slide there, the dissent, look at the folks on the dissent: Kennedy, Thomas, Alito, and Sotomayor. Far right, well, some far right, some left. It states, the court's reasoning does not take into account the fundamental principles or the practical dynamics of the initiative system in California, which uses this mechanism to control and to bypass public officials. The same officials who would not defend the initiative, an injury the court now leaves unremedied. So remember, that's what the initiative process is for.
Yes.
Is to do things that the government won't do. But this decision allows the government essentially to veto anything that's enacted by initiative by allowing it to be challenged in court as unconstitutional and having no one there to defend it.
Democracy? Where art thou?
Right. And this indicates that the California Supreme Court said that these folks, the proponents of the measure, did have the right to defend it. And as the dissent further indicates, the court's opinion today means that a single district court can make a decision with far-reaching effects that cannot be reviewed.
Oh man!
So the outcome of the case, the short-term outcome is a great outcome, but the long-term outcome, I think, is extremely problematical.
The democratic process.
Yeah, well, let's just say a state, by initiative, the voters of a state pass campaign finance reform, and of course the politicians don't like that, because the politicians who are currently in office are those who have been elected under the existing system of money. So they just say, well, we're just not going to. Well, if somebody challenges the constitutionality of this, we're just not going to defend it. Right? So this is a...
I'm so fascinated with what you're saying. It's time to take a break, and my director is going to yell at me if we don't take a break, and then we'll come back and talk some more about what's going on. Shall we break, Mr. E? Yeah, the mics are off. Okay, we're back. Thanks for staying tuned. And for you viewers who missed the opening of the show, Conversations with Dr. Don is an ongoing series of one-hour standalone talk shows where I interview interesting people like most of you out there about who they are as unique, one-of-a-kind individuals, and about whatever it is we've decided to talk about tonight. We've been talking about the legislative process, not in Salem, but also in Washington, and with my friend Dan Meek, who is so deeply involved in these kinds of things to do with justice, real justice for ordinary citizenry. So let's get back to where we were, Dan, can we?
Sure. I just review a couple of other U.S. Supreme Court decisions from the past week or so. Back last year, the usual 5-4 majority in a case called AT&T Mobility decided that a corporation or anyone could ban class actions by putting into a contract, like let's say your cell phone contract. Your cell phone contract will say that you, the customer, agree not ever to be involved in any class action against the company, and in fact that you agree to give up all of your rights to challenge anything the company does in court, and that if you have any dispute with the company, it has to go to private arbitration. So the U.S. Supreme Court a year ago said, yeah, that's fine, and we'll enforce that. And in fact, it doesn't matter. It doesn't matter even if the contract violates a whole bunch of state laws. That is, most consumer protection laws are on the state level, Unfair Trade Practices Act, etc. So even if this agreement that you sign, let's say it's a cell phone customer, violates a whole bunch of state laws, that's fine, because Congress in 1925 passed the thing called the Federal Arbitration Act, which said that if parties can agree to arbitration if they want to, just like any other contract. But the U.S. Supreme Court elevated that into saying it means that if you enter into an agreement to arbitrate, then basically you give up all of your rights under state law. So you would think that that was something Congress could, that is based not on the Constitution, but on a law that Congress passed in 1925. So Congress could fix that. But of course they won't, because the Republicans control the House of Representatives as a result of the Democrats not fixing Citizens United in 2010 when they had the opportunity. Now, a couple days ago, the U.S. Supreme Court extended that decision in a case called American Express Company versus Italian Colors Restaurant, and said that not only can a corporation force you to give up all of your rights under state law, it can also force you to give up all of your rights under federal law. It said in that case the restaurant wanted to sue American Express for antitrust law violations. But the contract, it's basically a credit card, merchant thing. The contract with American Express required the restaurant to agree not to do that. and to take everything to arbitration, but you know, and not to join together with any other merchants in order to contest anything that American Express does. And the court said, yeah, that's fine too. And so we'll just we'll just let corporations basically contract their way out of all consumer protection under state law and all protection under federal law of antitrust law or other things that are designed to protect consumers.
Oh, man.
So we don't have any consumer protection law anymore. And you might have noticed you're getting in the mail or online or email notices from the various corporations that you do business with. Oh, by the way, here's the new agreement. Here's the new agreement you have to agree to in order to continue to get your cell phone service or whatever. And all of the new agreements incorporate this mandatory arbitration clause and require you to give up basically all of your rights.
And you have no recourse.
Right.
Wow, it's capitalism run amok.
That's right. And as I mentioned earlier, all of this is the result of the Citizens United case. This slide indicates what happened after Citizens United was decided. Mm-hmm. This shows the amount of independent money that was being spent in races for the U.S. Congress and president before Citizens United. Citizens United was at the beginning of 2010, and you can see that before that, what one of these what Public Citizen described as liberal candidates were getting more money than conservative candidates
Public
in corporate
Citizen.
independent expenditures. Yes,
Mm-hmm.
that's the blue. The blue is the liberal. They were getting more money in 04, 06, and 08.
Mm-hmm.
So then when Citizens United came along, the Democrats looked back and said, well, what do we care? We're getting more money from the independent expenditures anyway. Mm-hmm. But voila, the independent expenditures then reverse in later in 2010. About twice as much go to conservatives, and in 2012, about 3 times as much go to conservatives.
Man. Money.
So, right. So that's why when you said, "What can you do about this?" It's that's a good question.
Take to the streets.
I guess so. Yeah. The other thing that we could talk about is what's going on in the Oregon legislature.
Yes, let's do that.
Because they're supposedly wrapping up their session this week, although I certainly expect it to go on for at least another week or more. Mm-hmm. When I go down to the Oregon legislature, I, of course, attempt to get them to do something in the way of campaign finance reform. And in particular, they could adopt a joint resolution and send to voters a measure to amend the Oregon Constitution to authorize limits on campaign contributions and expenditures, although it's not absolutely clear that that's needed. And in every session, a couple of those resolutions are introduced, and in this session, they didn't even get a hearing. Not only do they not get any vote even on the floor or in committee, they don't even get a hearing.
Would that resolution then become law if they got the votes and it was passed?
If the resolution were passed by a majority vote in the Oregon House and Oregon Senate, it's then sent to Oregon voters as a ballot measure.
Yes.
Yeah. But they won't do that. Instead, what they're doing is doing the main problem I have with this legislature is their attacks on the initiative process. Of course, the legislature, there's an inherent tension between the legislature and the initiative process because the people using the initiative process do what the legislature won't do, mm-hmm. by definition. So the most problematic bill is, as this slide indicates, is SB 154, which transforms any minor mistake by a petition circulator or other employee of a paid signature gathering effort into a Class C felony by the person responsible for the effort. So basically,
Class C felony.
For the past, because of the adoption of rules over the past 20 years that make it very technical to collect signatures on petitions, it's very difficult for all volunteers to follow those instructions, and it has become impossible to get a measure on the ballot using only volunteers. I think that the only ones that have been put on the ballot using only volunteers in the last 20 years have been the measure to forbid certain types of abortions. And I think that's it. So paid signature gatherers have become absolutely necessary. And what this does is it says that if you're paying any circulators and anyone violates in any way the laws or rules pertaining to petition circulation, that becomes a felony for the person who is paying the circulators. Here's how it works.
A felony.
A felony. Let's say that you have circulators who are out collecting petitions, and in order to get a measure on the ballot, the petition sheet usually has blanks for 10 signatures, and then a blank for the signature of the circulator, etc., and some other information. So inevitably, when you're submitting 30,000 of these sheets, some of them will go through and without the circulator signature on it.
Yeah.
Okay, that's a violation of law. Fine. It's punishable by if it were prosecuted by a fine of $250 and the signature sheet doesn't count. Under Senate Bill 154, however, the organizer of the campaign has to affirm that the campaign is complying with all laws and has to affirm that under penalty of perjury. So if the campaign then doesn't comply with all the laws in every respect, the organizer of the campaign has committed a Class C felony that is punishable by a $125,000 fine and 5 years in prison.
Oh my God. Capitalism run amok again.
So that's the reform of the initiative process that the Oregon legislature is undertaking. In addition, they've also instead of making more disclosure of the sources of campaign funding, they have been considering bills to make less disclosure of campaign funding. In particular, there's a bill, it started out as HB 2419, it then became HB 3513, it became 3523. And it changed currently in the last 6 weeks before an election, candidates and ballot measures are required to report their contributions received within 7 days that they're received. What this law does is it changes that to 14 days. So you get an extra 7 days not to disclose who your contributions are coming from. During only the last 14 days of the election cycle, it requires that contributions over $1,000 be reported within 2 business days, which means either 2 to 4 days, depending upon what day of the week it's given. But I don't think it's necessary to delay from 7 days to 14 days every other contribution, and in fact all contributions during the period of time from the 42nd day before the election to the 15th day before the election. So they're going for less disclosure rather than more. Senate Bill 145 was also, as it passed the Senate, had a giant loophole for campaign finance by allowing the formation of for-profit corporations, by eliminating the requirement that for-profit corporations formed simply to make contributions and expenditures in political races, identify their sources of what's called paid-in capital, or stockholders. The Oregon's had a law for decades that requires the persons who are stockholders in such corporations to report their identities and their employers and their occupations within 7 days. Well, the Oregon Secretary of State proposed just repealing that. And the rationale was kind of like the rationale of the Supreme Court when it came to the Voting Rights Act, and that was, well, no corporation has ever made such a filing. No corporation has formed for this purpose. I said, well, the reason they haven't formed is because they have to then report all of their sources of money within 7 days and their occupations and employers. That's why they don't form. But if you repeal the law, they will form, because it means you can form a for-profit corporation, take money from secret sources, use it for campaign contributions and expenditures, and never disclose the source of the money. Fortunately, the House Rules Committee today adopted an amendment that would remove the repeal of that law. So at least they listened to me on one thing.
You scored one win.
I scored one win. That's right.
You going to have some martinis tonight to compensate?
No. No, I will not.
Yeah. What a hard job you've got down there, and that's your life anymore.
Well, it's embarrassing to admit that, yes. But at least they'll be hopefully be out of session in a week or two.
How many people appreciate the work you're doing?
2 or 3. You. You, David Delk, Linda Williams, a few others. Not many.
Really appreciate what you do, my gosh. Takes a rare bird to have that sort of a makeup, that kind of a personality and that kind of intent to go at it and day after day. And even when you have the kind of results you've been having so far this time of year, as you're reporting here so far, it can be pretty disappointing. But it's a few people like you that make it work.
I forgot to mention the nepotism bill.
Oh, yes.
This is a good one. This did pass, both House and the Senate, and Governor Kitzhaber signed it. And that is under Oregon law currently in effect, like as of now. Let's say you're a public office holder. You're on the city council of a city, and you want to hire a relative of yours for a city job, or give a relative of yours a city contract. Well, under existing law, you have to disclose that the person is your relative, and you have to recuse yourself from the decision. Mm-hmm. So the other members of the city council have to decide if necessary to hire that person or appoint that person to an office or contract with that person for services. Sure. Well, so what the Oregon legislature has done is that it has changed the definition of
nepotism?
Of relative.
A relative.
The restrictions are still there.
I'm not sure I want to hear this.
Well, the restrictions are there, but now relative, the term relative, does not include aunts, uncles, nieces, nephews, half-siblings, stepchildren, and in-laws. It used to include those, but now it doesn't.
What's left?
A
wife, brother, sister?
Spouse. Yeah, spouse, mother, father, brother, sister. Oh, so there's one thing Oregon needed, and that's more nepotism. And that's what we got. And the other bill I went down and testified against was, in particular, was House Bill 3513, which would have essentially eliminated the open meetings law in Oregon. It removed the requirement, or would have removed the requirement, that government decision-making bodies meet in public. It would have removed that requirement if the meeting involved fact-gathering activities. Well, I think pretty much all of them include fact-gathering activities. If the meeting is not on a, quote, budget, fiscal, or policy matter with no definition of budget, fiscal, or policy, or if the meeting is an on-site inspection. So I went down and testified against that bill. Unfortunately, it did not proceed beyond the House committee that heard it. But the discouraging part about the legislature is that when I go down there and testify against bills, as I've done for the last 30 years, I'm usually the only people there who are there on the bills that I testify against, or even for predominantly, are the full-time paid lobbyists. That's it. Occasionally there are bills that involve such things as medical marijuana that a lot of people come down and testify about. But most of the time, it's very, very little testimony, very little public input.
My gosh.
Not that public input makes much of a difference, but
oh man. Yeah. And you're looking forward to next year?
Well, I always look forward to even-numbered years because the legislature can only be in session for 30 days. Mm-hmm, mm-hmm. So that makes the year a lot more enjoyable. Mm-hmm.
When are you going to write your memoirs?
I'd probably never. By the way, if folks want to get involved in any of my nefarious activities,
Yes.
this is a number to call and an
Yes, thank you.
email to get to the Progressive Party of Oregon. We have our monthly meetings on the second Tuesday at 7 p.m. Every second Tuesday, and we try to address issues like these and try to bring them to public attention, which is getting more and more difficult with the scaling down of the press in Oregon as well. You might have noticed that the Oregonian is going to go to 3-day delivery now.
I just heard that.
Yeah. 3 days or 4 days?
4 days, I think it is.
4 days delivery? Yeah.
What's happening to the media anymore? Printed page is going by the wayside?
Yeah, and that's kind of that's too bad, because I think the printed page presents information in a way that's different than online. It presents information kind of in a large scale that you can just sort of skim over and see things that you might find interesting that you wouldn't otherwise know about.
Yes, yes.
And that's different than looking online. Looking online is kind of more of a directed search. You'll say, okay, I want to see something about, the Defense of Marriage Act or whatever.
Yeah.
And so you don't really get
An overview kind of a...
you don't get exposed to other events or ideas, just because when you're reading the newspaper, for example, just because they're on the page.
Oh,
So what else do you want to talk about, Dr. Don?
I don't want to talk about anything more.
Okay.
I've had enough. So, what else is worth talking about in the legislative front that would be of interest to the viewers?
Well, I think
Any
that
positive news?
one thing that's also in the news when it comes to the United States Congress is the fight mainly by Jeff Merkley, Senator Jeff Merkley of Oregon, on the filibuster.
Good man?
Yes, good man. After he got to Congress, after he got to the Senate and was there for a couple of years, he realized that the big problem is the filibuster in the Senate.
Yes.
Of course, that made a lot more difference when the House was Democratic, because in that case, things could be done. Useful bills could pass both the House and Senate, except for the filibuster. So the useful bills couldn't pass the Senate without supposedly 60 votes. It's really amazing how the alleged 60-vote rules only applies when it comes to doing good things, and doesn't apply when it comes to doing bad things. For example, as this slide indicates, that Clarence Thomas in 1991 was confirmed by a vote of only 52 to 48. No 60 votes for him. Samuel Alito in 2006 was confirmed by a vote of 58 to 42. No 60 votes for him.
Oh, man.
But when it comes to doing these sort of things, it doesn't take 60 votes. It only takes 60 votes when the Senate wants to do something that's good. But Jeff Merkley, after 2 years, saw that a real problem was the filibuster.
We got to stop in about 30 seconds. Or
Okay. In any event, he's tried to overcome it. At every step of the way, he's been undermined by the Senate Majority Leader, Harry Reid, and it's kind of like Charlie Brown with the football.
Whoops!
Jeff Merkley keeps trying to kick the football, and the Democratic leadership in the Senate keeps removing it.
It kind of reminds me of you and your work.
Right.
So it looks like it's close to time for us to stop visiting and get ready to say goodnight. Keep your pens and pencils handy, because you may want to jot down something that we'll show you in the closing credits. And thank you again for coming on. It's always a pleasure to have you.
Sure, thank you.
To visit with you. That was not just what the work you do, for the work you do, but how you go about doing it and how you talk about it. And I'm sure my viewers like you too. I get good feedback about what you do when you're here. How about some public service announcements, Mr. E? There's a broadcast schedule in Washington County for this show. My shows regularly. I have a fresh show every week that first airs on a Thursday in Washington County. And to watch my shows on the web, Google Don Baham YouTube. There's maybe a couple hundred shows on the web over the years on my website. And ACLU, the American Civil Liberties Union. Without the ACLU, our civil liberties would be further down the tubes than they are. Join the ACLU. I've been a member now for 40,000 years. Next, let's talk about, to get my shows broadcast regularly by your local public access station, go to www.pegmedia.org and have the shows shipped directly to your local public access station to be broadcast locally rather than on the internet on my persons. Okay. Corporate personhood, that's what it all comes down to for me. We got to end corporate personhood. Go to www.movetoamend.org to figure out how we can end corporate personhood and restore our democracy to what it was intended to be. And now it's time to say good night. Thanks for watching this episode of Conversations with Dr. Don. And now my favorite thought for the day, again, it's the same one, KFC, and not Kentucky Fried Chicken, Dr. Don's KFC, kind, friendly, and charitable. Be kind, be friendly, and be charitable to you too, and be nice. It's simple as that. Thanks again. Good night.